Good afternoon, everyone. I'm Dion Shumby, CEO of Consumer Healthcare Products Australia, and it's a pleasure for me to welcome you to this webinar this afternoon. I would like to extend a special word of welcome to our colleagues from the TGA, Gillian Mitchell and Nicole McClay. These are exceptionally busy times for many of us, and particularly so for the TGA. So we appreciate it very much that Gillian and Nicole have made themselves available this afternoon. John Skerritt was originally scheduled to present, but unfortunately he had to offer his apologies because there are much more pressing issues that require his attention at the moment. We've allowed ample time for questions, and we'll try to cover as many as possible. If, however, we don't get to all of your questions, we give you an undertaking that we will respond to those by email after this webinar. So what are we going to cover today? First of all, Steve will start to provide a bit of context for the presentations and the discussion to follow. He will then introduce Gillian and Nicole, who will spend some 30 to 40 minutes highlighting key developments in relation to advertising arrangements and complaints handling. They will then hand back to Steve, and he will elaborate on some relevant aspects of the medicines and medical devices review, reforms and the implementation thereof. And he will also tell you about a new self-regulatory service that will commence on the 1st of July. As I said earlier, we'll wrap up with a Q&A section, 45 minutes, depending on how many questions we get. We don't need to go the full way, so if we finish early, so be it. Otherwise, we aim to finish at 5. And before you go, we ask you to please complete a very brief poll to give us feedback of your impressions of the webinar, and this will assist us to plan for the next one. So with that, I would like to introduce our first panelist, Steve Scarf, who is the Regulatory and Legal Director at Consumer Healthcare Products Australia. He looks after the regulatory and technical team, and he also provides in-house legal advice as well as consumer law supervision for our meetings. So over to you, Steve.
Good. Thanks a lot, Dion. And welcome everybody to this afternoon's seminar. What I'd like to do before we get into the two main presentations for today is give you a bit of context, a bit of scene setting really, before we launch into the major parts of it. So there's been a great deal of regulatory change in relation to therapeutic goods in Australia in the last 1 to 2 years, but in particular in relation to the advertising of therapeutic goods, there's an increased sanctions and penalties regime in place. There's a new advertising code in place. There's a new complaint system in place. And the 12-month grace period that was introduced with the new code for those advertisements that were compliant with the old TGAC and not compliant with the new one, that 12-month grace period has now elapsed. And on top of all that, the safeguard of mandatory pre-approvals will come to an end on the 30th of June this year. So what you've got is an incredible amount of change happening, and at the same time, this important safeguard is being taken away. So in that context, what we plan on doing is offering a voluntary self-regulatory service called AdCheck, which we will be running from the 1st of July this year onwards. And so for today's session, this is really what it's all about. It's about how can advertisers and those who cause the advertising understand and meet their obligations in this changing environment. So what I'd like to do now is to hand over to the TGA, to Gillian and Nicole, to take you through the obligations and liabilities now and post 1 July. So I'd like to introduce Gillian Mitchell, the First Assistant Secretary for Regulatory Practice and Support Division, and Nicole McClay, the Assistant Secretary for the Regulatory Compliance.
Thanks, Steve, and thanks, Dion. Thanks for having us this afternoon. My name's Nicole McClay. I'll speak first to our fairly short presentation, and then I'll hand over to Gillian to talk through the remainder. So in relation to my first slide there, thanks Steve, I've been asked to talk this afternoon about the advertising reforms that the government have introduced and what's changed. So in around 2015 was when the review was first commissioned and completed. And there, as Steve said, a number of changes have been introduced from March 2018 through to now. We'll see the final change introduced in June of this year. One of the primary changes that was agreed upon was based on the advice of the panellists that conducted the review, that consistency was needed between the way that medicines are regulated in advertising and the way that medical devices are regulated when it comes to advertising, as there was quite a bit of inconsistency. As you know, it's only certain medicine advertisements that currently require approval before publication. And that's ads that relate to TV, to newspapers, magazines, and so forth, but not medicine ads that, for example, appear on the internet or in pay television. So there was inconsistency between medicines and devices, but also between medicines themselves. And so as part of addressing that, the government decided to remove the requirement, the mandatory requirement for those certain ads to be pre-approved. And that ends on the 30th of June. But in order for that to happen, a number of other things had to happen first to allow that, to allow a shift from a pre-publication approval screening approach to a self-regulation post-publication compliance approach. And so the changes that have been introduced to allow that to come about was to introduce a stronger compliance framework. And that was about enhancing the enforcement powers, the sanctions and penalties in the Therapeutic Goods Act to allow a more graduated compliance enforcement approach to be applied to any non-compliance that might happen in ads. So there we saw a number of new options for compliance being introduced. There's a new strict liability offences that removed the need for the TGA to demonstrate a likelihood of harm. So rather than us needing to now prove that, it is a strict liability, there are strict liability offences. As you know, the ability to issue infringement notices for strict liability offences was introduced. There was also a new power to apply an injunction for advertising to be ceased while a case was investigated, and that's through application to the federal court. There's a power for substantiation notices to be issued and directions notices. The direction notice is, as it says, requiring certain actions to be undertaken on the part of the advertiser, and whether that's to remove the advertising, to publish a retraction, is another example of what we can direct. In relation to the substantiation notice power, that's a way for us to seek additional information to, for example, substantiate the claims being made, and that appropriate evidence is held for those claims. And we also are now able to issue a public warning notice if it is in the public interest to do so. So there were the changes that came about there. As I said, that framework allows for a more graduated response. It means that we can take lower level action through to, if necessary, criminal and civil action. You may have seen on our website that we have, under the new framework, commenced 2 civil proceeding cases. One's been concluded with Peptides Clinics Australia, and we have another one underway with Evolution Supplements Australia, where we've also been able to issue an injunction. So we are beginning to use the new powers. We've needed to issue a number of infringement notices, but our preference is still to do assisted compliance. And I'll talk a little bit more about that. That is by far our preference. Another one of the measures that needed to be introduced in order to move to a more self-regulatory approach was to provide greater clarity in the requirements themselves. And that's where the Advertising Code 2015 was replaced with the Advertising Code 2018. We provided more prescription within the new code. So there's more detail around what is a restricted representation, what is a prohibited representation. There's details around what can be advertised to children. There's more detail and clarity around what it means for prominently displayed and communicated, and that the brand name is not the test for that. In preparing the new code and bringing in that new level of detail, another good example is greater clarity around what's required when advertising online on the internet, where the consumer is unable to touch and feel the good when making a purchase and deciding to make a purchase. And it all comes down to our overriding policy objective, which is allowing consumers to make informed health choices. So in making the code, we did undertake quite a bit of consultation, and it was made on the 30th of July 18, but with an effective date of 1 January 2019. And then, as Steve said, during 2019, there was that 12-month transition period where we used enforcement discretion in relation to compliance between the 2 codes and moving between one and the other. The other change that was made was the CRP, the Complaints Resolution Panel, wound up their work, and the TGA became the single body for compliance and complaints handling. There's some sound logic behind having the one body for compliance. There's the obvious intelligence information that's gathered through running the complaints handling system, the results of surveillance, access to data and records and so on, which are all necessary to run an effective compliance function. And with TGA as the single body, all that information, all the skills are all held within the one area. And it's also consistent with the other offences in the Act. The other offences in the Act are managed from a compliance perspective by the TGA, and this is just another part of those. As I alluded to, the education program was one of the areas that we focused on most in setting up these reforms and a new way of doing things. So we've conducted face-to-face training. We established the advertising hub on the website. We realised that that has outgrown its original shape and version. There's too much content on there now for its original architecture, and I admit that it's difficult to navigate. So we are reviewing that. We'll be issuing a new version of the advertising hub, and we'd like to see more content added in there. We're hearing your feedback that examples are a really valuable tool for you, and that lengthy and more detailed guidance, whilst useful, is not the thing that you go to on a day-to-day basis. So you're looking for shorter fact sheets, you're looking for examples that show what's compliant and what's not compliant. And so we are designing a new part of the advertising hub that will offer those different examples for you, building on the ones that we've offered through the training programs and the seminars that we've run. You might have seen Beans ads. It'll be that type of thing. But we believe that helping advertisers comply is a much better outcome than needing to take compliance and enforcement action. In relation to our complaints handling model, you know, hopefully that education program is working, because, you know, a large part of the complaints that we receive are not about those advertisers who are trying to comply with the framework and operating within the system. Over 40% of our complaints about products that are not on the ARTG to begin with, and are avoiding, or perhaps inadvertently avoiding, regulation. And you know, we need to focus on those types of ads, as well as ads that, you know, promote prescription medicines. You know, I gave a couple of examples of peptides there, which, you know, can cause actual harm, and that's where our compliance and enforcement efforts are focused. The other major change that was introduced was the establishment of the Therapeutic Goods Advertising Consultative Committee. This is a really important part of what we do. It's a fairly large committee. It has representatives from industry, so CHP are a member. It has media organisations represented, health professionals, consumer representative groups such as Choice, Country Women's Association, the Consumer Health Forum Australia, and others. And we've also got government and other regulators on there, such as the ACCC. And we find that that gives us a balance of perspectives. Advertising of therapeutic goods has multiple stakeholders. And in writing the code, in preparing guidance, in you know, considering other aspects of the reforms and of the way that we regulate, it's really important that we take into account each of those different perspectives and balance the interests to come up with a balanced regulatory approach. And that's the role of the consultative committee. They're a really important advisory service for us, support for us. And I think, you know, Gillian may talk a little bit more about it when we talk about the independent review of the reforms that's underway at the moment. And I think for me, that really sums up the major changes without going into far too much detail. And I might hand over to Gillian.
Thanks so much, Nicole. So, so that's a really nice segue into where we are at the moment. And Nicole mentioned a review. So one of the things that Minister Hunt committed to when the recommendations in relation to the reforms were being discussed in Parliament was that 2 years from their implementation, that we would have an independent review to look at the impact of the reforms. So that review is now underway. It started earlier this year and it is due to provide a report to Minister Hunt in the very near future, really, probably in about before the end of this financial year. So Rosemary Sinclair has been appointed, as it says there on the screen, to lead the review for us. The purpose of the review is, as it says there on the screen, to look at the impact and the effectiveness of the reforms. So the terms of reference are on the TGA website. I actually, to find them today, noting Nicole's comments about the website, I typed in Rosemary Sinclair to the search function and it was the first document that popped up. So if you haven't seen the terms of reference and you would like to, that might be a quick way to get to them. So really what Rosemary is doing for us is assessing the impact of the new advertising measures. So that means the amendments to the code, our role as the single body looking at complaints, the broadened sanctions and penalties that Nicole outlined. We've also asked, or the Minister has also asked Rosemary to have a look at some of the other broader areas that we're involved in. For example, the consumer and industry education program, our performance measures. So you may be aware that we have some KPIs that we are required to try and adhere to in relation to the resolution of complaints and the like. What the review is not doing is actually reopening some of the policy that has changed. So, for example, Steve mentioned, and so did Nicole, the removal of the pre-approvals function at the end of this financial year. So that's not on the table, nor are broader legislative amendments outside the impact of the advertising reforms. So you might be asking yourself how you can get involved in this review. We have been working through the Therapeutic Goods Advertising Consultative Committee, or TGACC, as it says there on the screen for short. Rosemary Sinclair has had a number of consultations with members of the committee, and if you have any particular feedback that you are yet to provide to your representatives on the committee, then I would really encourage you to do that. There's still time. The 22nd of April is next week on Wednesday, I think it is. So if you could get any feedback through to your representative on the TGACC by then, that would be very much appreciated. You might be wondering whether the review is actually progressing as per our original timeframes, and yes, it absolutely is. Whilst COVID-19 has taken over much of our work, Rosemary is progressing with her review in accordance with our original timeframes, and she will be providing her report to Minister Hunt by the end of this financial year. It will then be up to government as to what happens next, and we might see, depending on what's happening with COVID-19, we might see a little bit of a hiatus before we get any outcomes. But again, it'll just be subject to the conversations that Minister Hunt has with his parliamentary colleagues once he receives that report. So if I move on now to the last slide, we did just want to talk a little bit about your responsibilities in this world of therapeutic goods advertising. I think this is really a key issue for us. As is the case with all businesses, the therapeutic goods industry operates within a legislative framework. And that legislation is at all levels of government. And it's not just therapeutic goods legislation, it's other legislation, things like consumer law and so on. So it's really, really important that advertisers and businesses do their due diligence before publishing or broadcasting an advertisement about therapeutic goods. So this means that we would really hope that you are taking advantage of all the tools that we have available to you, like the guidance on the TGA website about the advertising code, attending sessions like this and other education sessions that we've had. And I would hope right now that you are looking at the material that we're putting out around advertising therapeutic goods in the context of COVID-19. You should also be using your peak body or a regulatory affairs consultant, or you might be using independent legal advice as well. But making sure that you have processes and procedures in place to assist you comply with your legislative obligations is very important, and it will become more important once the mandatory pre-approval scheme ceases on the 30th of June. It is not going to be replaced with another statutory scheme. We do know that some organisations may offer a vetting service to advertisers, and Steve's already mentioned what CHP is planning to do, and I think he's going to talk a little bit more about that later in today's webinar. One of the areas that CHP has asked us to comment on, and this is the second last ticker box, if you like, on the screen. Obligations are the same whether you advertise or cause the advertising. So I just wanted to pause and say a little bit about that. There is some questions to us about what this actually means. Is there a difference between advertising and causing the advertising? and also whether a publisher's defence applies to therapeutic goods advertising. So what this means, for example, is that the product sponsor or retailer is the entity that advertises, and then the publishing newspaper is the entity that causes the advertising or facilitates the advertising. The effect of the advertising reforms and the introduction of the sanctions and penalties that Nicole talked about apply equally to both those who might be undertaking the advertising and those who actually cause the advertising to be out there in the world. And this includes publishing, it includes broadcasting, it includes social media. So the obligations when it comes to therapeutic goods advertising apply equally to both. There are some exemptions though, and it tells you there in the asterisk dot point where there might be an exemption, or exception is probably a better word to say. Now this is a limited publisher's defence, as it says there on the screen, and it's only where the publisher can show that prior to making the publication, they took reasonable steps which led them to assume that the advertisement was consistent with the code. So reasonable steps include things like proper identification of the advertiser and notifying the advertiser that it is their responsibility to comply, getting an assurance from the advertiser that the advertisement doesn't contravene content requirements and any prohibitions, or authorisation from the sponsor to make the advertisement available to the public. And I think Steve might also be going to talk a little bit more about this later in the presentation. I am going to finish up at this point. We're trying to save time, so there's lots of time for questions, and hand back to Steve. Nicole and I will stay online and we'll participate in the Q&A session. But before I do, just a quick reminder again that we are really interested in your feedback. And so please, if you've got anything that you'd like to feed into the independent review, 22nd of April, next Wednesday, get that information to your TGA CC rep. So back to you, Steve.
Great. Thanks a lot, Gillian, Nicole. I really appreciate your time today, taking the attendees through those previous slides and the reforms, and also touching on the publisher's defence. Also, what I'd like to do, I'm not sure Dion covered this in the intro, but I just wanted to let you know that the presentations from today will be made available after today's session. So if you are there looking at these slides as they're going past, don't worry, you'll be able to get copies of the slides after today's meeting. I'd also like to thank all of my colleagues here at CHP Australia. This has turned into a huge event, much bigger than we initially imagined, and with the impact of COVID-19, it's being done in a format that we've never done anything like this or on this scale before. So yeah, a special word of thanks to my colleagues, and also for the TGA for developing their workaround so that they could participate on this platform. So what I'd like to do now is really to take you through the industry perspective and then my thoughts on the future situation. So this is an outline of what I'm going to be touching on today. I'm not going to go through this in detail. Suffice to say that we'll be looking at some of the bigger picture issues and some of the micro issues as well. And really it's about what's happening, what might happen in the future, and what some of the regulatory detail actually involves. So just to take you through what's happening, a little bit of the background. So as you know, some advertisements for therapeutic goods need to be approved now before they can be used. This mandatory pre-approval applies to medicines only. And as I think as Nicole said, the MMDR looked at aligning medicines requirements with devices requirements because there was that difference of approach between the two types of products. And the other interesting thing about mandatory pre-approvals is that it only applies to certain media, certain broadcast and certain print media. And up until November last year, the mandatory pre-approvals function was covered by 2 associations. And from November last year, that the entire responsibility for OTC medicines and for complementary medicines was assumed by CHP Australia. So So what's happening? Well, after decades of consumer protection, mandatory pre-approvals for therapeutic goods advertising is coming to an end. And I think, as Gillian said, it's coming to an end, it's finished. The policy decision about, whether it should be there or not be there is done, it's finished. People need to move on with their lives, I guess. So that's been pretty clear. But from 1 July, that protection won't be there anymore. So what does that mean for people who've relied on that protection? And also, what does it mean, because your obligations as advertisers and parties who cause advertising still apply. So you've still got the same obligations, but this safety net's being removed. So what we'll be doing from 1 July this year is offering a voluntary compliance service called AdCheck. So why is the government abolishing mandatory pre-approvals? Well, this comes back to the Medicines and Medical Devices Review from July 2015. And recommendation 55 was that the whole process of vetting and pre-approval of advertising of therapeutic products to the public should be stopped in favour of a more self-regulatory regime. And the government's response to that recommendation was that they accepted it, and that they're noting that the increased enforcement powers and the increased education by the TGA was critical for managing concerns by consumers and by healthcare professionals in accepting the recommendation that mandatory pre-approvals would cease. Now, prior to the legislative change, the Senate's Community Affairs Legislation Committee looked at the bill to remove pre-approvals and came up with a number of recommendations. And of relevance here today, this is the recommendation that they made, so that the committee noted the importance of self-regulatory models and recommends that the TGA investigate ways to better support the effective functioning of self-regulatory models by industry, including the potential for further strengthening of the penalties regime if needed. So in a nutshell, mandatory pre-approvals are being removed, they're coming to an end. The government's response and the Senate's response was that they should be replaced by self-regulatory models, and that the TGA should be involved in supporting that. And as you can see from today, Gillian and Nicole are here. They've been, giving up their time to present this material and to answer questions from attendees at today's seminar. But what I'd like to do really is just to look at some of the context within which this has changed. And this change to mandatory approval is not happening on its own. There's been a whole suite of regulatory changes to therapeutic goods regulation in Australia. But of importance to today's seminar, we've got the new TGAC, we've got new advertising complaints processes, and the increased sanctions and penalties. And what I'd like to do is to just touch on each of those three in a little bit of detail before moving on. So, as Nicole said, there's a new advertising code. It's interesting to note that there was no substantive change to the code for nearly 13 years, from 2005 to 2018. And so advertisers and those involved with advertising had a very long time to get comfortable with the code, to work out exactly what did and didn't work, what was compliant, what was not compliant, what some of the nuances and the subtleties might be with some of the wording. And then there's been 3 versions of the code since June 2018, and there's more changes coming. So what the feedback that I'm getting is that there's still some uncertainty about the precise requirements. There's still some subjective elements in the code that are proving difficult or problematic for advertisers. There are some sections of the code that are difficult to apply, and that the code needs to be read in the context of the Advertising Hub and the TGA's guidelines. And as well as that, there's a new complaints process, there's a new decision maker, there's a new approach to publishing of decisions, and the feedback we're getting is that it makes it difficult to work out exactly how the subtleties, the subjectivity, the nuances of the code are applied to advertising. I mean, I think most people understand that you can't advertise prescription medicines to consumers. Most people understand you can't advertise therapeutic goods that aren't on the register. But, you know, what are some of the things around having the evidence to substantiate something, whether it's something's prominent or not? These are whether it's consistent with a public health message. These are the sorts of things that advertisers struggle with, really, and that's the feedback that we're getting, and the requests for assistance from members in those areas. I guess what is crystal clear is that there are increased sanctions and penalties, and I'd like to spend a little bit of time on that. The explanatory memorandum that accompanied the legislative change was very clear that the change was about stronger compliance and enforcement powers, about broader sanctions and penalties. It's about protecting the public and allowing the TGA to respond appropriately. So the TGA, and Nicole's mentioned this, the TGA has a range of sanctions and penalties. I'm not going to go through these in any detail, but suffice to say they range from educational letters at the lower end of the spectrum all the way up to criminal prosecution. And how the TGA approach that, or how any decision maker would approach that, is to look at the nature of the breach, look at the advertiser's attitude towards compliance. And I think this is an important point, and I'll come back to this later on, that it as an advertiser, it's your attitude to compliance that can affect the outcome of any potential breach. So they look at the history of non-compliance and looking at the potential risk to the public. So I think it's important to stress this, and I don't think I can stress this enough. It's not just the advertiser, it's anyone who causes the advertising could be liable for compliance. And to give you a sense of the scale involved here, so these are the penalties that are identified in the Act, and they range anything up to $1 million for individuals and $10 million for companies, and up to 5 years imprisonment for some of the criminal penalties. So there's some very serious consequences here. And to just illustrate some of the recent enforcement examples, I've got a list here of the fines, infringement notices and penalties from this year, and this year's not that old, and from last year as well. And there's over $450,000 worth of sanctions, fines and penalties in this year alone, and we're halfway through April. So I think this is a very good indication that the TGA has these powers, and they are committed to using them. So pre-approvals are coming to an end. What could take the place of mandatory pre-approvals? Well, what we've come up with is a self-regulatory system. So as per the MMDR, per the government's response and the Senate committee, a self-regulatory system should replace the mandatory pre-approvals, and that's exactly what we're planning on doing. So the new service will be called AdCheck, and we've got a specific logo for that as well, and we'll be offering that service from 1 July this year. So how will this new service work, or some of the details? I'd like to take you through some of that now. And what we've done when we've developed this system, this service, what we've tried to do is anticipate some benefits for all stakeholders. So, and I'll go into that in a little bit more detail later on, but what we've tried to do is develop something that has something to offer everyone, really. It will be voluntary, it'll be self-regulatory, but it will be open to all advertisers, members of CHP Australia or not. It'll be open to review advertising in all media, and it will cover medicines and devices. And the good news, two pieces of good news here, is that the ASMs who currently perform this function will be involved in the provision of this new service. So their expertise, their knowledge, their experience will all be brought to bear in delivering the new service. And the pricing and processes are going to be as consistent as possible with the current system, so that we'll minimise the disruption, minimise the discomfort of transitioning to this voluntary service. We want to make it as familiar as possible to advertisers and people involved with advertising. So there's going to be a similarity to the process and a similarity to the pricing structure as well. So how will it work? Well, there'll be an online submission. You'll get acknowledgement and there'll be an invoice issued, obviously. The assessor will provide you with feedback on advertisement. And there'll be provision of advice where necessary to achieve compliance. And this is something that's a bit difficult at the moment. At the moment, it's really, you're forced into using this process and you're forced into an approval or a rejection outcome. So the dynamic going forward will be quite different. It'll be more of a collaboration. You'll be entering the process voluntarily. The assessors will be able to discuss compliance with you and work towards a compliant outcome. So I think it will be a lot less combative, a lot less sort of forcing to a conclusion. It'll be much more collaborative, much more of a discussion taking place. So if the ad's considered to be compliant, you'll be issued with a unique number that you can include in that ad, or you can associate with it in some other way. And importantly, that number can be verified through us by anyone who is approached to run that ad. So if you develop an ad and have it come through the service and you want to publish it in a newspaper, or you want to put it on TV, or you want to give it to someone to broadcast in some other way or display, then they can verify with us that the ad has gone through the compliance service. Now, if the ad as it stands is considered to be non-compliant, there'll be advice given on how compliance might be achieved. And if it's not capable of being made compliant, the application will just be closed. So there's not going to be a list of rejected advertisements published. You're not forced, as I said, to come to this yes or no conclusion. If you're not making progress, you can withdraw from the process at any time, really. So what I'd like to do now, to give you a break from listening to me, is play a very short video that we've developed, and I'm hoping that it'll work. We've done a couple of tests today on it, and fingers crossed it works. But it's a short 1-minute video which explains the service in hopefully a lot more concisely than I've been able to do so far. So let me start that up.
Are you involved in advertising to consumers? Change is coming. After June 2020, the government's mandatory pre-approval of therapeutic goods advertising to consumers will end. Companies that create and place ads will still have the legal responsibility to ensure their ads are compliant, but without the benefit of this compliance safety net. Advertisers, publishers, broadcasters and media agencies not only risk heavy fines and sanctions, but also brand and reputational damage. That's where AdCheck comes in. AdCheck is an expert advisory service from CHP Australia that provides comprehensive compliance checks for all forms of direct-to-consumer therapeutic goods advertising. To help minimise your compliance risk, AdCheck experts can check ads, provide training and assist with complaints. Ad checks will be performed by CHP compliance experts who previously conducted mandatory pre-approvals. Don't run the risk. Contact the AdCheck experts now.
What I'd like to do now is to delve a little bit more deeply into some of the nitty-gritty, some of the details about what it means to advertise and what it means to cause advertising. So I think the important place to start here is that all of the compliance sections in the Act start with this formula, that they apply to parties who advertise and to parties who cause the advertising. So it's absolutely essential that if you are captured by either of these two, or described as by one of these two parties, then you need to know what your obligations are. So firstly, in terms of what it means to advertise, I think that's pretty clear. There's an extremely broad definition in the Act itself, which says basically that any statement, design, representation that's intended, whether directly or indirectly, to promote the use or supply of goods is considered to be advertising. So the important thing there is that it's any statement, even indirectly, to promote the use or supply. So it's extremely broad. And it does cover a very wide range of activities. What's less clear, I guess, in terms of the legislation is what does it mean to cause advertising? And the TGA have published a list of parties, which is available in the TGA's online guidelines. And what I've done here is just highlight a few for specific attendees at this afternoon's seminar, parties who are considered to have caused the advertising. So retailers, publishers, broadcasters, media service providers, advertising agencies, and influencers. All of these parties could be held liable under the Act for non-compliance. Now, are there any exceptions? Yeah, I think so. Nicole touched on this as well, the so-called publishers exceptions. And there's 2 sections in the Act. I'm not going to go through these in detail. You can go through those 2 sections at your leisure. But so it's 42 DLB and 42 DMA that include this exception. So what does it mean? How do these exceptions come about? So they apply if you're a broadcaster, a datacaster, the SBS, or if you're a publisher of a print edition of a newspaper or magazine that's available to the public for purchase. So if you're any one of those 4 parties, broadcaster, datacaster, SBS, or publishing a newspaper or magazine that Australian consumers can buy, then you can take advantage of this exception. But only where, as a result of steps that you took, it was reasonable for the person to assume, so it was reasonable for you to assume that the ad was compliant. So what does this mean? Well, if you're one of those 4 parties, you can take advantage of the protection, but it's only in relation to those 2 sections of the Act, and it's only where you can show that you took steps to make sure that it was reasonable to assume that the ad was compliant. Now, that's relatively easy to do now while there's mandatory pre-approvals, and mandatory pre-approvals has been seen as a sufficient step to trigger that exception. But without mandatory approvals, what are the options open to these people? So you could take the word of the advertiser, you could assess the compliance yourself, which would require the development of in-house expertise. You could rely on a credible third-party compliance service, which is where I think our service will come in, and there may be others. And I think Nicole alluded to some of those in terms of agreements with the advertisers and conducting your own verification checks. So why are we so supportive of pre-approvals now and compliance reviews in the future? Well, I think from our point of view, it's quite clear that mandatory pre-approvals have protected consumers from being exposed to non-compliant advertising. They've protected advertisers and sponsors and those associated with the advertising from the risks of penalties and sanctions for non-compliant advertising. And the end of mandatory pre-approvals has been positioned, or was positioned, as part of the MMDR as a reduction in red tape, as a reduction in regulatory burden. But there is a view that removing pre-approvals may in fact increase regulatory burden as it increases the need for complaints, as it increases the need for action after the fact rather than beforehand. So, you know, the apt phrase, particularly for our industry, is that, you know, prevention is better than cure. It's better to stop ads from non-compliant ads from ever going to air than to chase after an advertiser afterwards for a non-compliant ad. So just to take you through a couple of pieces of information that we think supports this view, and that is that between 60 and 70% of the advertisements submitted to our ASMs require some form of approval or some sort of modification before they can be approved. Now that ranges from fairly small changes to fairly substantial changes. And without that pre-approval intervention, those non-compliant ads would go out and consumers would be exposed to them and advertisers would be exposed to the risk. Another useful or interesting fact from our point of view is that looking back at the CRP data, where 98% of complaints lodged with the CRP were found to be in breach, only between 5% and 9% of the complaints justified related to advertising that had been pre-approved. So once again, there's that protection factor there. There's a protective effect of having your ads looked at before they go to air. So why would you want to use this new ad check service? Well, like I said, we've designed this system with all of the stakeholders in mind. We've tried to come up with something that offers you know, an advantage to everyone involved. And what I'd like to do, I'll quickly take you through some of that. So from an advertiser's point of view, there's a lot of self-interest involved. So you get an arm's length objective review of your materials before they go to air. You're reducing the likelihood of breaches occurring as a result of that. You also get our assistance with any complaints that you might receive in relation to reviewed ads. And so we think that the fact that you use the ad check service should be taken into account as a mitigating factor if the ad subsequently found to be in breach. And just take you back to the previous slide. So this is a demonstration of the advertiser's attitude towards compliance. It's their past behaviour in the lead up to the breach, which will be relevant in determining what the appropriate penalty and sanction is, if anything. As an added benefit, I guess, is that it's a demonstration of good faith and a demonstration of the respect for the relationship that you have with those parties that you're giving your advertisement to. It's reassuring to them that their ad's compliant and their risks are thereby reduced. And for those who cause advertising, so we talked about the publisher's exceptions and the steps that you can take to take advantage of that exception. So what steps can you take? Well, you can become an expert yourself. You can employ people. You can upskill those people, train those people to perform that service. You can rely on the advertiser completely through a number of assurances that you might ask them to give you. Or you can rely on a credible third-party compliance review. So just a couple of questions really. So if you don't meet the requirements for the publisher's exception, then you're in the same boat the advertiser is. And the fact that the ad check service was used should be taken into account as a mitigating factor. And if you do meet the requirements for the publisher's exception, then this third-party compliance review should allow you to reasonably assume that the advertising is compliant. So if you're not the advertiser but you're causing the advertising, then in either of those two cases, this service should be of value to you. There's also benefits for consumers in protecting them from being exposed to non-compliant advertising, and for the TGA themselves. So a reduction in the number of non-compliant ads will necessarily lead to, or should lead to, a reduction in the number of complaints. Although I do take Nicole's point that the large proportion at the moment relates to advertising that's got nothing at all to do with the compliance framework, that they're products that shouldn't be advertised at all. They're products that aren't even on the register. But what it might also do is to help focus on those areas where the ads are not being approved. So the presence of that number in your advertisement will be a signal to the regulator that it's been through the review process. And then finally, for industry as a whole, in addition to the benefits for individual advertisers, it'll be a demonstration to everyone who interacts with us that we're a mature, responsible industry, and that's something that we'll all benefit from. So just in summary, mandatory pre-approvals are being abolished, and the government response to that recommendation and the Senate's review was that it should be in favour of a more self-regulatory regime, that the self-regulatory models were to be the preferred replacement to that mandatory scheme. And at the same time, there's changes to the advertising code, to the complaints processes themselves, and there's increased penalties and sanctions. So advertisers and those who cause advertising are responsible for compliance, and we think this new ad check service, which will be a voluntary service from 1 July, will be of great benefit to all stakeholders.